Court of Appeal. We have two cases on the docket today. We'll take them in the order they appear. The first case today is UMB Bank versus Florida Department of Transportation. Counsel, if you're ready, you may proceed.
May it please the court, Elliot Shurker on behalf of UMB Bank. With the court's permission, I'll reserve 3 minutes for rebuttal.
So noted. The
Santa Rosa Bay Bridge Authority's bonds went into default in 2011. The debt was accelerated in 2013. The bonds remain in default. The bonds are payable from and secured by toll revenues, which revenues indisputably have been inadequate to pay the principal and interest on the bonds. The authority is required by Section 5.02 of the bond resolution to establish adequate tolls, but the authority has been defunct since 2014 after a traffic study recommended significant toll hikes and the authority refused to act. The lease purchase agreement in Section 1.04 requires FDOT to act on tolls if the authority fails to perform its obligations. The trustee notified FDOT in 2015 that the tolls were inadequate to repay the bonds pursuant to an expert study. FDOT refused to raise the tolls despite the study's findings, and despite a 2017 legislatively mandated feasibility study's finding that FDOT was legally obligated to raise the tolls to fund the bond payments and likely would be sued if it failed to do so. A 2019 study that recommended significant toll increases, and a December 2019 summary judgment on FDOT's counterclaim, a judgment that FDOT has never challenged before this court, in which the trial court ruled that FDOT is legally obligated by Section 1.04 to establish tolls as recommended in the 2019 report, because the authority has failed to do so under Section 5.02 of the bond resolution. And it took the trial court's February 2020 order compelling compliance with the counterclaim summary judgment to get FDOT finally to raise the tolls. But now FDOT says it's years of delay in complying with LPA Section 1.04. Indeed, its prior denial of any obligation to raise tolls is of no moment, and that FDOT should essentially get off scot-free for damages caused by that delay. The trial court agreed, and that's what brings us here today. To start at the beginning, the question is whether bondholders can be heard to assert a claim for breach of the LPA. And the answer must be yes for several reasons, all arising from unambiguous contractual language. First, under LPA Section 1.04, FDOT and the authority adopted Section 5.02 of the bond resolution, quote, for the benefit of the bondholders, and guaranteed that the revenues would be sufficient to service the bonds. Second, Section 3.03 of the LPA states, quote, the LPA shall be deemed to have been made for the benefit of and shall be a contract with the bondholders. It further states in Section 3.03 that the department and the authority, quote, consent to the bringing of any proceedings in any court of competent jurisdiction in the state of Florida by any holder or holders of bonds for the enforcement of any and all covenants, terms, or provisions of that agreement. And third, although Section 3.22 of the LPA states that the bondholders may enforce by specific performance as third-party beneficiaries, Section 3.23, the very next section of the LPA, specifically states that, quote, no remedy conferred upon or reserved to the authority, the department, or the bondholders, quote, is intended to be exclusive of any other available remedy or remedies, but each and every such remedy shall be cumulative and shall be in addition to every other remedy given under this agreement now or hereafter existing at law or in equity or by statute. The first amended complaint and the currently operative second amended complaint plead a claim for damages arising from FDOT's long-lasting breach of Section 1.04 to make the bondholders whole, which specific performance going forward by definition cannot do. This is not double recovery, nor is a claim for damages barred by the election of remedies doctrine. If FDOT abides by the trial court's orders compelling performance, the bonds may eventually be paid off, but much later in time than was contemplated when the bonds were put on the market. That's the basis for our incidental damages claim, as we explained to the trial court. Under well-established precedent, contract damages are not inconsistent with equitable relief. Both remedies affirm the contract, so pursuit of one remedy cannot waive the other remedy.
But aren't the damages you're seeking, aren't they also inconsistent with the bond offering statement? The offering statement itself just suggests and states very plainly that the bonds are special limited edition revenue bonds of the authority and shall not constitute an obligation of the state. There's other language in the bond statements that are consistent with that.
Yes, ma'am.
So how can it be that there are damages arriving from non-payment of the bonds that are anything but repayment?
The revenue for payment of the bonds, repayment of the bonds, comes from toll revenues. Of course it does. It's guaranteed by the bond documents. It's under the LPA. It's repayable in the ordinary course from the bond revenues. But we're not seeking payment of the bonds. We're seeking damages for FDOT's breach of a contract that obligated FDOT in no uncertain terms to provide for toll revenues that were sufficient to repay the bonds. We not only lost 5 years of adequate bond payments, we lost it, as we explained to the trial court at the summary judgment hearing, we lost the use of that money during that period of time. We lost reinvestment opportunities. For that matter, the bonds mature in 2028. The bonds are undisputedly not going to be paid off by 2028, which leads to further incidental damages. FDOT breached a contractual obligation that we are entitled to enforce. And there's nothing in the documents that says, as to the bond repayments themselves, that FDOT couldn't raise the revenues from the tolls to cover that particular aspect of the damages. Your Honor, it's almost like we're at the courthouse door saying, please, may we come in to plead a breach of contract claim, and the party on the other side says, well, there's no money from which you can collect because these are revenue bonds and not general obligation bonds. We haven't even reached the question of trying our damages claim. We're talking about collection when we're still having the courthouse door slammed in our face. So although the bonds are repayable only from toll revenues, our damages are our damages. And we're being cut off before we can even get a chance to present those damages to a jury. And again, I return to section 3.23 of the LPA, which specifically provides that all remedies are cumulative, which is completely in accordance with common law. There's nothing inconsistent about seeking a recovery of damages by affirming the contract with specific performance in affirming the contract. And of course, the law is very clear that one does not waive an available remedy unless the contractual documents specifically state that all other remedies are waived. To the contrary, these contractual documents state that all remedies are available. So because the bridge bonds are revenue bonds and not solely and not general obligation bonds, the trial court ruled the trial court essentially, as I said, slammed the courthouse door in our face and said we can't go forward with our claims.
Counsel, if you had, if the authority were not defunct, could you bring the same action in the same way against the authority?
If the authority had refused to raise the toll revenues, yes. FDOT stands in the authority's shoes.
And your remedy there is raising the tolls?
Well, our remedy going forward is for them to do what them, meaning the authority and or FDOT, to do what the contract obligates them to do, to provide for toll revenues sufficient to repay the bonds. But we had about 5 years in which we requested FDOT to raise the toll revenues, in which FDOT was presented with expert study after expert study and simply told us to pound sand.
What I'm asking is, that, so the authority has limited financial revenue, right? It's only from the tolls.
Right, that's correct. The authority's revenues from the tolls.
So if the Department of Transportation is stepping into the shoes of the authority, are you not stepping around that what would have otherwise been the nature of the authority's ability to remedy the action by reaching into a new source?
Those are not at all, because the department has its own obligations independent of the authority. The department is obligated to act if the authority does not. The department is obligated, its denial of that obligation notwithstanding for so many years, to raise the revenues so that they're sufficient to repay the bonds. and the department refused to do so even after a summary judgment was entered on that, and it required a court order enforcing the summary judgment to do it. So the department has its own, the question about the department's obligation, Your Honor, I guess what I'm trying to say has already been settled by the summary judgment on the counterclaim. The department is obligated to provide for sufficient toll revenues to repay the bonds, period. That's not even before the court as a question. So that now that we know that there's an obligation, we know that obligation was breached, we're coming forward with a claim for damages from that breach. This is a contract case. This is at its heart a very simple contract case. The contract is unambiguous. The bondholders are entitled to bring an action. The bondholders are entitled to all available remedies under Section 3.23. And the department is saying, let's stop right here because these are only revenue bonds and not general obligation bonds. So we cannot be held liable for the undisputed breach of contract for a period of 5 years. You're going to get your money someday, not in 2028 when the bonds mature, but you'll get your money on the bonds someday. But the loss of the use of that money, the reinvestment opportunities that were lost, the reinvestment opportunities that will be lost after 2028, we get off scot-free for that. The contract cannot be read to allow that. It's that simple. It's a straightforward reading of the contract and straightforward obligations that the department breached under the LPA. I'll reserve my time for rebuttal. Thank you very much.
May it please the court, Mark Peoples for the Florida Department of Transportation. The bondholders made an investment. They were apprised of the risks, they were notified of the limitations, and they made an investment. And so far, that investment hasn't paid out as they had hoped. The bondholders are now asking the department, and by extension, the taxpayers of this state, for a bailout. To my mind, this is a paradigmatic example of privatized gains, socialized risk. The trial court wouldn't condone it, and neither should this court. One thing I'd be remiss if I didn't point out is that even if, as the bondholders' counsel would have it, somehow the full faith and credit of the state is intended as a backstop for these risky investments, the department did not issue these bonds. The authority did. The department's role here was to operate and maintain the bridge. The authority sold the bonds. The authority sold the bonds to finance its construction, its operation, and other expenses. The arrangement was that the department would, as part of its operational responsibilities, would collect tolls and disperse them to the authority, who in turn, pursuant to their contractual arrangements, would disperse them to pay down debt. And once the debt was paid down, the department would be reimbursed for the operation and maintenance expenses that it's incurred. The department hasn't been reimbursed a dime. I have the latest figures. They're not of record because they are the latest figures that I can share with the court, but they are substantial. And we have not been reimbursed one dime for our operation and maintenance expenses.
Well, counsel, if you could, let's turn to the language of the lease purchase agreement. And it seems to me that the bondholder's best argument is that there seems to be some tension between 3.22 and 3.23. So 3.22 on the one hand states that the contract shall be enforceable by specific performance and that no other remedy at law is adequate to protect the interests of the parties and the bondholders. And then in the next section, it then states, no remedy conferred upon or reserved to the authority of the department or the bondholders is intended to be exclusive of any other remedy. So why is it not the case that the bondholders could seek specific performance and then damages for the loss of the use of the funds for 5 years?
Well, okay. There's a couple of responses to that. First, Mr. Shurker got started on the contractual language which provides that the bondholders are intended third-party beneficiaries per the contract. But he didn't address the implications of that. What does that mean? What that means under the law is third-party beneficiaries, their rights are derivative of the contracting parties. They stand in the shoes of the contracting parties. Their rights cannot exceed the contracting parties' rights. Mr. Shurker told you, and I agree, that under the contract, the authority is charged with raising tolls. The authority could not sue the department for not raising tolls when the authority thought that they should be raised. And because the bondholders purport to stand in the shoes of the authority, neither can the bondholders. I've not heard them yet address exactly how they purport to stand in the shoes of the authority, yet maintain a claim for damages that the authority could never bring.
But you don't quarrel with the fact that specific performance was appropriate here?
No, I don't.
Not even as to the third-party beneficiaries?
No, the contract, I read that language in 3.22, the specific performance clause. I read that language to waive the defense to a specific performance claim that you have an adequate remedy at law, you can just get money. Indeed, when they sued us for specific performance, we didn't raise that defense. But just because you can sue for specific performance does not mean you can also seek damages. Damages and specific performance are inconsistent. This isn't a contractual matter. This is not a matter of a conflict between 3.22 and 3.23. This is a matter of election of remedies. And under the common law, if a specific performance claim is taken to judgment, and this was, we have an order, y'all discussed it with appellant's counsel, requiring the department to raise tolls. If that's taken to judgment, then an inconsistent remedy, such as damages, is unavailable. That's under the common law, not through some conflict between 3.22 and 3.23. And one other thing I'd point out is that the nature of their damages claim. And I think that Judge Long was getting into this when he was asking, if you would sue the authority's only source of revenue would be the tolls, so is this not an end around that limitation? Their complaint seeks damages in the form of what they call forfeited tolls. They define forfeited tolls as millions of dollars in higher tolls that were lost and could and should have been collected and paid to plaintiff for the benefit of the bondholders. That sounds a lot to me like damages would go to pay the bonds. I don't know another way to read that language. That there's seeking money that is not toll revenue to pay down the bonds. And as you pointed out, Judge Rowe, the offering circulars and the contracts are surfeit with references to the bonds must be paid solely from toll receipts. Nothing in the bonds or the bond resolution shall be construed as obligating the full faith and credit of the state.
Well, what do you make of the bondholders' argument that you could raise the tolls even higher to compensate them for the other damages that they're seeking?
Well, there's a sliding scale, right, and if both the department's traffic consultants report and their consultants report are of record, but there is a sliding scale of demand and setting the toll. As you raise the toll, demand goes down. And so, sure, we could raise the toll to $33 million and just have one person drive through the toll, and all of a sudden we're reimbursed for our expenses. But that's I don't think that that's quite what, I don't think that's a realistic option. Right now, and there's no dispute about this, all toll receipts are paid to the bondholders, every dime. Again, the department hasn't received one dime for its expenses, one dime for its operation or maintenance expenses. It's simply going to take longer than the projections had hoped.
Did the department make any counterclaim for those expenses?
Well, no, because the bondholders don't owe us the expenses. The authority owes us the expenses after the bondholders are made whole. We're not there yet, and we won't be there for quite some time. Anticipating that they may contend that the summary judgment on the counterclaim didn't quite satisfy their specific performance claim. I want to point out a couple of things. They moved to dismiss the counterclaim. And one basis for the motion to dismiss, this is a record 533 through 535, they specifically argued that the counterclaim raises the same issues that will be determined in the specific performance claim. And then at the hearing transcript on this summary judgment motion, the trial court, I think, was a little confused as to whether the judgment on the counterclaim was satisfied their specific performance claim. I think that one counsel for UMB said that no, that all that was at issue was the counterclaim, not the count one, not the specific performance claim. But the trial court at record 3834 referenced an agreement between the parties that whether FDOT was responsible for raising the tolls would be decided on cross motions for summary judgment on the department's counterclaim. Counsel for the department confirmed that was his memory, and counsel for UMB didn't object. So, and really the practical effect, which the specific performance claim said raised tolls, and the judgment on the counterclaim said raised tolls. Again, the law looks to substance, not form, and in substance, the specific performance claim was granted.
Counsel, let me ask you a question
Yes.
to sort of maybe take us back to basics just a little bit. So you have the authority is issuing these bonds. They have this limited revenue source, and I get all of that. But DOT also participates in this process and agrees to take on some responsibilities. And to your point, as you began about privatized profits and
Right.
socialized risk,
Right.
that sort of thing. At the same time, though, the Department of Transportation has accepted some responsibility to carry out some functions, and they've failed to carry out those functions. Is your position that they can't be held responsible for that other than the specific performance? And you're reaching that conclusion just by the limitation of the language, the enforcement obligations provision?
Not just from that, but also I continue to stress that as third-party beneficiaries, they're standing in the shoes of the authority. The authority could not sue the department for not raising tolls. They purport to arrogate to themselves a right that the contracting party would not have against the department. That, as far as I could tell, that point's never been answered. Their answer in their brief, when we raised it in the answer brief, was essentially, no, as third-party beneficiaries, we have the right to sue the department.
All right, well, you're
we've never
acknowledging-
questioned whether they have the capacity or standing to sue.
You're acknowledging that they have the ability to seek specific performance, though they already have, and that's been done, right?
Yes?
So my question is, recognizing that the Department of Transportation has agreed and taken on certain responsibilities, Is the specific performance of raising the tolls the only possible way to hold the Department of Transportation accountable for their failure to comply with the terms of the agreement?
Okay. First, I don't concede that we did fail to comply with the terms of the agreement. It's true that the trial judge entered summary judgment, a non-final order of summary judgment on the department's counterclaim, but the department reserves the right to appeal that order on plenary appeal. So I can't agree
Fair
with
enough.
the premise of that.
Fair enough.
But I think your question is, assuming that this court does affirm that counterclaim summary judgment, is specific performance the only remedy that they have under the contract?
Yes.
Yes.
And that's based on your interpretation of these contractual provisions, excluding any other available remedy.
No, it doesn't have much to do at all with 3.22, the interplay between 3.22 and 3.23. It's because the damages that they seek are from toll revenue, or rather from revenue that is not toll revenue. But the damages that they seek are expressly for tolls that were lost and should have been collected and paid to the bondholders. Under the contract, the only available revenue to be paid to the bondholders is toll revenue. To reach outside that to general revenues would make the department a guarantor of this risky investment. That's not what the contract does. The trial judge so found, and this court should affirm. If there's no further questions, I think that I'm out of time. I ask the court to affirm. Thank you.
Thank you, counsel.
May it please the court, I believe I heard my opponent say that we should lose because the authority can't sue FDOT to raise the tolls, and we're only third-party beneficiaries. It would never happen under these documents that the authority would sue FDOT, because FDOT's obligation to raise the tolls only kicks in when the authority refuses to do so. And at that point, Section 3.03 of the LPA kicks in, because Section 3.03, as I said in my opening argument, this is from the record at 3435, is 3.03 is where the department and FDOT, the department and FDOT, consent to the bringing of any proceedings for the enforcement of any and all covenants, terms, or provisions of this agreement. So our dispute with FDOT only arose when the authority refused to do its job. We're not merely third-party beneficiaries standing in the authority's shoes at all. I also heard my opponent say that FDOT did not issue the bonds, which is sort of a neither here nor there so far as I understand these documents. FDOT, under the LPA, assumed certain obligations. I heard lots of complaints about how FDOT hasn't been repaid for all of its expenditures on the bridge. FDOT is going to be repaid for its expenditures on the bridge after the bondholders are made whole, and that's expressly in the LPA. Judge Rowe, you're entirely correct. We have no obligation as the bondholders to pay for the maintenance of the bridge. That's FDOT's obligation under the LPA. And what does FDOT get at the end of the day? FDOT gets the bridge. It's a lease purchase agreement. FDOT gets the bridge at the end of the day. That's its ultimate benefit. And at that point, FDOT is collecting the tolls and can apply that money to the maintenance of the bridge. That's exactly the way the agreement was structured from the very beginning. This is a purely contractual case. There's no inconsistency between the specific performance obligations that we enforced and the damages that we seek to recover. We are not in our complaint saying, just to be very clear, what you heard Mr. People say, we are not saying that our damages are recoverable from any particular source. We are not saying that our damages are recoverable based on the full faith and credit of the state of Florida. We are saying that FDOT, and you basically heard an admission, FDOT breached the contractual obligations and is liable in damages for those obligations, and they are not solely toll revenue obligations. They're the loss of money over 5 years, loss of money and reinvestment opportunity over 5 years that adequate tolls were not collected, despite our repeated invocations of the LPA, despite our repeated requests.
Is the only source of damages or payment of damages toll revenue?
The only source of payment of the bonds is toll revenue.
But what about from the department? If we were to agree with you, and if damages were available, where would they be paid from? Would it be toll revenue? It certainly can't be the general revenue, full faith and credit of the state of Florida.
Your Honor, I don't know, as I stand here, ultimately where the damages would be recoverable from. That would be a matter for the trial court to decide in enforcing any judgment for damages. But let me be clear about what 3.22 states, because I think it was being overread during my opponent's argument. What 3.22 states is that the covenants and agreements hereunder, including specifically the obligation of the department to ensure, operate, maintain, and repair the Series 1996 project, and to collect and deposit the tolls, in accordance with the terms of this agreement shall be enforceable by specific performance. We invoked specific performance to compel the department to collect and pay the tolls. That doesn't say, especially in light of 3.23, that our damages that were incurred during the period of time that FDOT was not collecting the tolls, our incidental damages, are not payable from the general revenue of the state of Florida. It doesn't say that because we're not paying the bonds by collecting those damages. But again, we're at the courthouse door with a claim for damages. And FDOT is saying, you may not be able to recover those damages from general revenues, therefore you don't have a breach of contract claim. And respectfully, that's like saying in a private contract dispute, I'm bringing a claim for damages, and the defendant saying I'm entitled to dismissal because I have no assets, all my assets are in my corporation's name, all my assets are in my spouse's name, I have no assets from which you can recover, and therefore your claim should be dismissed. That's not the law of Florida, and that shouldn't be the law when the department is acting in the same capacity as a private individual and agreeing to undertake certain important contractual obligations.
Okay, thank you, counsel. Your time has expired.
Thank you, Your Honor.
And thank you both.